There are some mistakes that people, though well-intentioned, make when they're trying to file for custody. Number one, responding and acting emotionally. Later on, you can say to the judge, well, I'm an emotional person, but if there's video, and nowadays everything's recorded somewhere, there's some ring picking up what you're doing. Now, if you're reacting emotionally, or perhaps over-emotionally, that sudden outburst of emotion might impact the court's view of who you are and whether or not you're capable of sound judgment and reasonableness. Oversharing too much in messages could be a mistake also, because there's always a context to everything that people write. There's always a context to every text that people send and every email that goes out. But you know what? Sometimes you don't get the context in the email because the context may be something that's not in writing. In other words, there may be some really bad discussion that occurs over the phone, and then you follow it up with a text. Well, the text viewed of itself may look horrible, but viewed in the light of the overall context may not be so bad. So you got to watch for that. Social media mistakes are always a big problem. If you threaten somebody through social media, or even if you didn't mean it, it could come back to haunt you. Also, pictures of you holding alcoholic drinks or doing something that may be questionably legal, that can also haunt you. I think a big mistake is ignoring the legal strategy that your lawyer sets forth. You know, a lot of times clients will say, and I hear them telling this in court to judges, I don't like this lawyer. He's not doing what I want. She's not doing what I say. Well, you know what? What you want and what you say is exactly what got you in this mess to begin with. Your instincts, while maybe helpful in your personal life, are not necessarily instincts that are helpful in a court of law. Your lawyer is not there to do what you want. And your lawyer is not there to follow what you say. Your lawyer is there to guide you based on their own experience of what will work and what won't work. And sometimes what you want to say and the proofs that you want to bring in won't matter. You know why? Because you want to bring in evidence from your brother-in-law that you didn't harass somebody. The problem is there's 10 neighbors who are standing in the hallway ready to testify what they overheard and what you did. So you know what? Your brother or your brother-in-law or your relative, that may not help you. It may be better off to say something like, there was an unfortunate incident, but they're only talking about an isolated incident. It doesn't give the whole picture. There may be some better avenue to pursue. And just because you want somebody to be brought in, that doesn't mean it's going to be relevant evidence. I cannot tell you how many times people have gone, and I hear these discussions, you walk down the courthouse, you walk down the hallway and you hear people talking with their lawyers, and I cannot believe that people hire lawyers, spend $500-600 an hour for them, and don't want to listen to them. It's unbelievable. So your instincts may be good for you, but they may not help your case. Follow the guidance of the people that you trust and hire. That's why you hire them, because you trust them. Follow their guidance, and ignoring legal strategy. It's one of the biggest mistakes people make when they file cases and they have divorce and custody matters.
248-588